Ever wonder what happens when a construction project in India hits a snag? And I'm not talking about like a little paint spill here. We're talking major delays.
Yeah, yeah.
That's where things get really interesting,
It gets complicated.
especially when it comes to who's holding the bag,
Right.
or in this case, the blueprint.
Yeah.
So today, we're diving deep into the world of extension of time disputes.
EOT for those in the know.
Exactly.
Yeah.
EOT for those in the know. And we've got court cases, expert opinions, you name it, all leading to how to navigate these kind of tricky waters and understand your rights.
Yeah, and trust me, this isn't just like legal jargon. This is about real-world projects, big money, and making sure everyone plays fair when deadlines get blown.
Exactly. And it all starts with the Indian Contract Act of 1872. Now, you might be thinking, 1872, they were building with mud bricks back then.
Right.
But surprisingly, this old law still holds the key to understanding modern-day construction disputes.
It's true. What's fascinating is that the act itself doesn't have a specific chapter titled,
Right.
construction delays.
Right.
It's more nuanced than that. It's about understanding the principles of reciprocal promises
Okay.
and how they apply to construction projects.
Okay, let's unpack that a bit. Reciprocal promises for those of us who don't speak legalese.
So it boils down to this. In a construction contract, each party's obligations are interconnected. Think of it like a perfectly synchronized dance.
Okay.
If the employer, the one who's commissioned the project, is late in handing over the construction site,
Right.
it throws the contractor's entire schedule off. Sections 51 to 54 of the Act basically say the contractor can't be penalized for delays that are directly caused by the employer.
That makes sense. But there's this other phrase I kept bumping into. Time is of the essence.
Oh, yeah.
It sounds pretty intense, like a ticking time bomb in the contract.
It is a significant clause, and that's where Section 55 of the Act comes into play. When time is of the essence is written into a construction contract, deadlines become non-negotiable.
Okay.
Missing them could even give the employer the right to terminate the contract.
High stakes indeed. But then I came across this case, Oil and Natural Gas Corporation Limited versus Emesis Seconded OCTG.
Okay.
And it kind of threw me for a loop.
Oh.
They had the time is of the essence clause, yet the court still allowed EOTs and compensation for the contractor. How does that work?
Well, that's where the intricacies of Indian law get really interesting.
Okay.
The court recognized that unforeseen delays can happen even when time is critical. What mattered in this case was the contractor's intent. They documented everything meticulously, proving the delays weren't their fault. Plus, they formally stated their intention to claim damages, which perfectly aligns with Section 55.
This is exactly why I love digging into these cases.
Yeah.
It's never as simple as it seems. Now, let's talk about a common pitfall the expert paper highlighted. Arbitrators splitting delays down the middle. The case of Ircon International Ltd VCR Sons Builders was a prime example. Why is this 50-50 split such a recurring problem?
Sadly, it often comes down to a lack of clear documentation. Imagine being an arbitrator, essentially a judge for these disputes, trying to untangle who's responsible for what delay without solid evidence. It's a nightmare.
Yeah.
The easy way out is often just splitting the blame down the middle,
Right?
but that rarely reflects what truly happened on the ground.
And that's where the expert paper's recommendation of using forensic delay analysis becomes crucial, right?
Exactly. Think of it as like a high-powered magnifying glass for delays.
Okay.
Instead of relying on finger-pointing and guesswork, forensic delay analysis uses specific methods to pinpoint responsibility. The paper highlights methods like impacted as planned, time impact analysis, and as planned versus as built.
Right.
These methodologies use hard data to prove exactly who owns what portion of a delay.
So if you're a contractor facing delays, you can't just say, hey, it wasn't me.
Right.
You need concrete proof. This reminds me of another case from the materials. McDermott International Inc. versus Burn Standard.
Ah, yes. That case is a game changer. They didn't just say they deserved compensation. They proved it with data. That's the power of this approach.
Okay, that's a powerful example for the contractors out there.
Yeah.
But what about the employers? What stuck out to you about how they can protect themselves in these EOT situations?
Remember that domino effect of delays we discussed?
Right.
And how it relates to reciprocal promises? The expert paper really stressed the importance of employers meticulously documenting everything as well.
Good.
If a contractor claims a delay due to, say, the employer being slow to approve materials,
Right.
the employer needs to have records showing when those requests were received, reviewed, and so on.
So it was like building a solid alibi, but for construction delays.
Yes,
You need that undeniable paper trail.
precisely. And it's not just about playing gotcha. Thorough record keeping by both sides can actually help prevent these disputes from arising in the first place.
Now let's switch gears for a moment and talk about this no-claim certificate.
Okay.
It sounds like a pretty powerful document.
It can be, yeah. It's a bit of a double-edged sword.
Yeah.
On the one hand, as we saw in the Union of India versus Onkar Nathbala and Sons case,
Right.
when a contractor signs off on a final bill that includes a no further claims certificate, it can prevent them from bringing any more disputes related to that project.
So in that sense, it's like the final word, the case is closed.
In certain situations, yes. Especially when it's crystal clear that both the employer and contractor fully understood what they were agreeing to. However, there are exceptions to this rule.
Okay, here's where I think things get really interesting. Tell me more.
The courts have recognized that no claim doesn't necessarily mean no claim ever.
Okay.
If a contractor can prove they raised objections to the certificate when they signed it, or if they had reservations documented at the time, that certificate might not hold up in court.
You're talking about situations like the Sanyukat Nirmata versus Union of India case, right? The contractor's objections ended up keeping their right to arbitration alive.
Precisely. And it's not just about no claim certificates either. The N. Sathyapalan versus State of Kerala case showed us that even those ironclad exclusionary clauses often found in contracts have their limits. If a delay is entirely the employer's fault, and we're talking about significant demonstrable delays, the contractor might still be entitled to damages.
It's reassuring to know that even when a contract seems to tie everything up in knots, there's still room for fairness.
Absolutely. Courts are increasingly understanding that these contracts aren't meant to be straitjackets. Things happen on construction projects. That's just the nature of the beast. The goal is to find a solution that reflects the reality of the situation, not just what's written on a piece of paper.
Which brings us back to that crucial element of proving your case right. It's not enough to just claim damages, you need to back it up with rock-solid evidence.
You hit the nail on the head. Take the Bharat Heavy Electricals Ltd versus Kanar Electricals Ltd case, for example. The court's message was clear. You can't just slap on liquidated damages without demonstrating actual quantifiable losses.
No more. Because I said so in the courtroom, huh?
Not a chance. And it's not enough to simply show some losses either. You have to prove the right losses, the ones directly caused by the specific delay in question. The MS Ambika Construction Co. versus Union of India case serves as a cautionary tale here. The contractor claimed they deserved compensation, but they hadn't maintained proper records to support their claims. The court ultimately sided with the employer.
So whether you're the employer or the contractor, meticulous documentation is non-negotiable. It's the foundation of any successful claim. But what about actually putting a number on those losses? How specific do you have to get?
It's not enough to simply claim general or vague losses. You have to get granular. The IJM Gayatri JV versus NHAI case provided a good example. Even claiming something like loss of opportunity needs to be meticulously backed up with specifics. How did this specific delay directly cause you to miss out on other projects? What evidence can you present to support this claim? These are the tough questions the courts or arbitrators will be asking.
It's like they say in writing, show don't tell, but for construction contracts. We've covered a lot of ground here, from the historical context of the Indian Contract Act to real-world court cases, all the way to specific recommendations from legal experts. For anyone listening who might be thinking, this is all a bit much, I need help, what would be your advice?
I'd say first and foremost, don't panic.
Right.
While we've delved into some complex territory today, knowledge is power. The key takeaway is this. When it comes to EOT disputes, clarity and communication are paramount.
Okay.
In fact, the expert paper we've been referencing highlighted this as a crucial point. Many of these disputes could be avoided entirely if the employer and contractor maintain transparent and open communication from the very beginning.
So it's not always about lawyers and contracts.
Right.
It's about good old-fashioned communication.
Absolutely. Think of it this way. If delays pop up, address them head on. Don't let things fester. Document everything.
Right.
Not to build a case against each other, but to create a shared understanding of the situation. That's where those contemporaneous records we talked about become invaluable.
It's like that saying, sunlight is the best disinfectant.
Right.
The more transparent you are with each other, the less likely misunderstandings are to escalate into full-blown disputes.
Exactly. And if you do end up in a disagreement, having that shared documentation makes the resolution process smoother. It's much easier to find common ground when everyone is working from the same set of facts.
That makes a lot of sense. Now, for our final takeaway today,
Okay.
let's address those listening who might be thinking, this is all well and good, but I need personalized guidance.
Yeah.
What would you advise them to do?
You're right. Every project and every contract is unique.
Right.
While this deep dive equips you with a solid understanding of EOT disputes, seeking guidance from a specialist can be invaluable.
Okay.
Look for someone who specializes in construction law and delay analysis.
Okay.
They can provide tailored advice, help you navigate the complexities of your specific situation, and ultimately protect your interests. Consider it an investment in peace of mind and potentially avoiding costly, time-consuming disputes down the line.
I couldn't agree more. Sometimes having that expert in your corner can make all the difference. Well, folks, there you have it. Our deep dive into the intricate world of EOT disputes in India. We journeyed through legal frameworks, dissected real-world cases, and I think most importantly, armed you with practical insights to navigate your own projects. Remember, clear communication, meticulous documentation, and when in doubt, expert guidance. Those are your allies in this arena. Until next time, keep learning, keep building, and keep those contracts airtight.